How long does a personal injury lawsuit take? Well, like most lawyer answers, it depends. The legal process can be frustrating, slow, and confusing at times. But I'm going to break down the 7 main stages of a personal injury lawsuit. Now, each case is different, but most cases will follow these 7 stages. First, we file a complaint. Then the defendant files an answer to the complaint. Then we move into a phase called written discovery. Next are depositions, and you have to have a compulsory medical examination. After that comes mediation, and if the parties can never reach a settlement agreement, trial. I'll explain what each of these stages means in more detail. But on average, it takes about 2 years from the time the complaint is filed to get to trial. Personal injury lawsuit stage 1, the complaint. If you've been injured because of someone else's carelessness and you have to file a lawsuit to recover damages, the lawsuit is started by filing a complaint with the court. This is a written document that outlines when and where the incident occurred and what the other person or company did wrong. The complaint will also state in general terms what type of damages you're seeking. The person that brings the lawsuit, that's you, is called the plaintiff, and the person that gets sued is called the defendant. There can be more than one defendant in a lawsuit. For example, your own insurance company, if you have uninsured motorist coverage and they either deny your claim or they deny paying what you're owed under your policy. Once the complaint is filed, it then gets served on the defendant, which means it's physically put into their hands to make them aware that they've been sued. And then we go on to the next phase. Personal injury lawsuit stage 2, the answer. This is probably not the answer you're looking for. After the defendant is served with the complaint, they have to file a response. Generally, their insurance company will hire an attorney to file a response for them. Sometimes there are motions filed prior to an answer, such as a motion to dismiss, but eventually an answer is filed. And in this answer, the defendant either admits or denies the allegations in the complaint. Generally speaking, they'll deny almost all of the allegations that are in the complaint. It is then our job to prove all of the allegations the defendant denied. In order to prove the allegations, we need evidence. And we gather most of that evidence through a process called discovery. Now, generally, the discovery process can be the longest part of a lawsuit and can sometimes last months or even years. The next 3 stages are all part of the discovery process. They are written discovery, depositions, and compulsory medical examination. These 3 stages can overlap some, but the next stage is going to be written discovery. Personal injury lawsuit stage 3, written discovery. Early in the lawsuit, we will receive written questions from the insurance company's attorneys. These written questions are called interrogatories. We will also receive a request for documents called a request to produce. There may be other types of written discovery, such as requests for admissions as well. The written questions will ask about your background, such as where have you worked and lived, and they will also ask you about how the incident happened and what you think the defendants did wrong. They will ask you to list all the doctors you've treated with both before the accident and after the accident. You'll also be asked if you've ever been involved in any prior lawsuits or ever been convicted of a crime. The questions may even ask about your marriage. Personal injury lawsuits get personal. The insurance company will ask for copies of your tax returns, medical records, photographs of your injuries, and photographs of the vehicles involved. By the time we receive these requests, we should have most of the information relating to your accident and your injury. But it's important that all the responses you give are both accurate and complete. We need to make sure we have a list of all of your prior medical providers, your prior home addresses, your employment history, and even any prior lawsuits or claims you filed in the past. After the written discovery stage, your deposition will take place. Personal injury lawsuit stage 4, depositions. This is the most crucial part of your case. The insurance company's attorney will get to ask you questions about your case, your medical history, your employment, and prior claims you've been involved in, as well as many other subjects. Your attorney will be with you while you're answering this question, as well as a court reporter who will transcribe every question and answer that's given during the deposition. Depositions in personal injury lawsuits usually last 2 to 4 hours, but there is no time limitation. This is one of the only times the insurance company's attorney gets to talk directly to you. Not only are they looking for information to poke holes in your case, they are also evaluating you. They are evaluating your demeanor, how you speak, how you interact with others, and your truthfulness. Ultimately, they are trying to get an idea of how a jury will perceive you if your case goes to trial. There are likely to be other depositions taken in your case as well. Depositions may be taken of other witnesses, the parties, and your healthcare providers. After your deposition, the next stage you're likely to be involved in is a compulsory medical examination. Personal injury lawsuit stage 5. Compulsory medical examination. The insurance company will hire a doctor or doctors that they can use at trial to talk about your injuries. Normally, the insurance company is looking for a doctor that can minimize your injury or say that it was not related to the accident. The insurance company's doctor will review all of your prior medical records, the medical records from your treatment for your injury, as well as your deposition transcript and MRI or X-ray films. The doctor will also physically examine you. These examinations can last from 5 minutes to an hour. After the exam is complete, the doctor will write a report about his opinions on your case. And once that report is complete, we will get a copy. The entire discovery process encompasses written discovery, depositions, and compulsory medical examinations. And this process can take many months to even years to complete. Personal injury lawsuit stage 6. Mediation. If the parties are not able to reach a settlement agreement on their own, the court will order us to mediation. We will go to mediation together and meet with the insurance company's attorney and a claims adjuster. The mediator will be selected by us and the insurance company's attorney. Most mediators are former personal injury attorneys or insurance company attorneys or former judges. Some mediators have a combination of those experiences. The mediator will facilitate settlement discussions with the parties and try to get to a resolution. Sometimes mediation results in resolution, and sometimes it does not. Mediation is not the last time to resolve your case, but at minimum, it's beneficial for each party to hear the other side's point of view, and often results in at least the parties getting closer to a resolution. If the parties are never able to reach a settlement agreement, then the final stage to resolve a case is trial. Personal injury lawsuit stage 7. Trial. Usually the only time you'll physically go to the courthouse is for trial. If the parties are never able to reach a settlement agreement, then the final option to resolve your case is trial. On average, it takes about 2 years from the time a complaint is filed to the time you get to trial. Your case will be a jury trial, which means it's decided by a group of your peers as opposed to the judge. Most personal injury lawsuits last about a week, and on the first day, a jury is picked. The jury is comprised of 6 people in a Florida civil case. After the jury's picked, the attorneys give their opening arguments, which summarizes each party's position. Then the evidence stage begins. Most of the evidence comes through witness testimony. This includes you taking the stand, as well as experts and other witnesses. But for the entire week, the jury is evaluating you, whether or not you're on the stand. The final day is closing arguments, and after closing arguments, the jury goes out of the courtroom to deliberate. Once they're done, they come back in, and either the judge or the clerk will read the jury's verdict. Although I'm ending the stages here, even after a jury verdict, there can be many other issues that the court still has to address that can last over weeks or months after the trial. Or there can be an appeal for a variety of reasons, the most common being the losing side thinks it should get a new trial. During our discussions about your case, I will often reference trial and a jury, because it's important that you and I evaluate your case on what a jury will actually hear and what evidence they will actually see. All of the stages I described will occur over months, likely years, and there will be other hearings as well with the judge, but most of those hearings deal with legal or evidentiary issues that the attorneys handle and don't need your participation. During your lawsuit, it's important that you respond to our office's emails and phone calls. Without your responses, we can't move your case forward. And always feel free to ask questions. We understand this process can be difficult, stressful, and confusing, but you hired us to advocate and lead you through this process, and that is what we're going to do. I'm Andrew Irvin, a personal injury lawyer in Winter Park, Florida, and for more free information on how to navigate the legal process if you're injured, make sure you follow and subscribe.